SJC-13326, Church of the Holy Spirit of Wayland and others, v. Mary J. Wilson and others.
Okay, Attorney Gramer.
Good morning. May it please the court, William Gramer, on behalf of the families who are here today seeking that this court uphold the appeals court's decision which protected the sanctity of a burial ground located on property formerly owned by the Episcopal Diocese in Wayland, Massachusetts. Your Honors, this case is about whether or not the rights afforded to burial grounds in the Commonwealth continue to exist upon the sale of property. This case, although the property was owned by a church and sold to a church, is not about the church's right to close that parish. It's not about the decision to sell that property for financial gain, and it's not about interference with any religious beliefs of either the Episcopal Diocese or the purchasing church, the Coptic church in this case. The common law in the Commonwealth and throughout the United States is clear that once land is devoted to use as a burial ground, it's fundamentally transformed. It's said to be then held in trust for the benefit of the heirs and of the deceased to their final resting place. There's a right that's created, and case law calls this right in the nature of an easement or an irrevocable license.
Are the cases
What about the statute? The statute that covers burial grounds?
So Massachusetts has a statute that makes it a crime to disinter remains, but there's no Massachusetts statute specifically about disinterment.
Does the statute address anything about when a burial ground ceases to become a burial ground?
No, Massachusetts does not have a statute like that. I'll talk about this perhaps more in a moment.
But the cases you rely on tend to be private burial grounds. They're not church cases, which are much more complicated, particularly a church case that says that the operation of the burial ground is subject to regulation, right?
They do. Most of the cases talk about either family burial grounds or other privately held grounds, but there's no distinction drawn in
Any case that involves a church burial ground that adopts the approach that you do, that it's not subject to regulation, and the point you began with, which is it doesn't interfere with religious practices, because it seems to me much more complicated here. The purchaser doesn't believe in cremation and does not want cremated remains on their property. That raises their First Amendment free exercise issue. The seller wants to sell the property because they want to close down the church. That implicates, I'm not saying it's dispositive, but it implicates their First Amendment rights to close their church, to be able to sell it. So I don't see it as as simple as you just posed it.
On the facts here, Your Honor, you have to remember that this burial ground was existing before the purchase and sale was signed. In fact, it was a condition in the P&S to remove the burial ground. So the purchaser here, the Coptic church, took with full knowledge of the existence of that burial ground.
And that it would be removed.
And it was a condition of sale that it be removed. What they didn't recognize, though, was the common law right that required there to be certain conditions existing in order to allow that removal. And that's what the Heinz case and other cases talk about. It's not just the sale. There has to be a finding. In the Tennessee statute, which my brother and sister say supersedes Tennessee common law, that statute also recognizes three fundamental conditions
But before
that
we
have
move
to
to Tennessee, what if the regulation here had said, the church remains free to close the burial ground and ask you to remove the urns? Then I take it your common law right would have no application, right?
Correct, and the appeals court addressed that issue, and they said in this particular situation, the Churchyard regulations and the certificate of interment contained no such language.
So
and it would have
that's
been
the
easy for
issue,
them
is
to-
whether the regulations, whether the appeals court or the trial judge correctly interpreted the regulations.
Correct, and the case law all talks about reading the contract in a reasonable manner And the amendment to the regulation that Your Honor cited to, whether that was done in a reasonable manner and implemented reasonably. Now here, the property was sold in January of 2016. 6 months later, in June of 2016, the Episcopal Diocese decides to amend the regulations. After the property's been sold and after they realize they're bound to meet this condition in the purchase and sale or be subject to damages from the buyer.
Right, so why is this case actually that complicated, that we have to travel down the common law in the 19th century and go to Tennessee and all of that? Why isn't it just, well, the contract provided that the church could change the regulations? Was the post-sale regulation a change contemplated by the contract that can be enforced?
Because here the contract, I submit, does not contemplate disinterment. When the buyer or parishioner here purchases a burial lot, and when they go through the process of burying their loved one, there's an expectation that that's final. There's nothing in the certificate of interment, there's nothing in the churchyard regulations that even hints at the notion that someday we may sell, in which case the bodies or the urns will have to be removed. That's just not contemplated. And so
Counsel,
when
could I ask you a question? Procedurally, we're here because of the motion to dismiss, right?
and motions for summary judgment.
Okay,
primarily.
well, is it, if I go back to what you said a few minutes ago, is this that we need a trial here? Not that you win, and I say specifically that because your point about the fact that 6 months post consummation of the deal was when they tried to amend the rules and regulations to say, hey, now we get to decide, and we're deciding because we've got to meet this condition. Isn't it the reasonableness of doing that that's an issue there? And doesn't that deserve a trial?
I think that the trial court could decide that as a matter of law on its face.
How?
That the fact that it was done after the sale for the specific purpose of attempting to comply with the purchase and sale agreement in this case. In fact, when they authorized the sale, there was a specific notation in the meeting minutes of the vestry that all efforts be taken to protect the memorial garden. They asserted that they exhausted those efforts, and then after the fact, after the sale, after there was objection by families, they decided to amend the regulations to give themselves the very power that they didn't have in either the certificate of interment or under the churchyard regulations.
To Justice George's point, you're assuming that the church didn't have that power because you're saying it was unreasonable to amend 6 months after the deal to meet the conditions of the deal
Correct.
as a matter of law?
Yes, that, the
But
attempt to
why?
amend.
Why is that unreasonable to meet the conditions of the only deal they could get, or the best deal they could get,
Because
post the deal?
when you apply neutral principles of law to this question, you look at the expectations of the parties. And again, somebody purchasing a certificate of interment in the memorial garden did not have an expectation of future disinterment. And so
Did they
You
have
can
an
fu-
expectation that it would continue as a churchyard?
the
it
certificate
would-
of interment and the regulations both talk about perpetual care. That is expressly in the contract terms.
And what, is it defined, is that defined?
It is defined, perpetual by definition is lasting forever, but there is some language in it that talks about maintenance of the memorial garden in terms of landscaping, removal of branches and debris and so forth, and maintaining it as a recognizable burial ground.
And so who now has that obligation under your theory?
So we think that the common law right of access includes with it the right to maintain and beautify and make repairs. And so that would be on the families in the first instance. Families who come to that memorial garden could rake leaves, they could pick up branches. If the fence was knocked over, they could fix it.
So I
Now,
guess that brings me back to sort of what you dismissed as not relevant to this case, which was the First Amendment issue. Now the Coptic church owns this land, including the churchyard, including the memorial gardens. And your position is that these certificates give the families the right to continue to go onto the new owner's land, who, on genuine religious reasons, believes that, his beliefs are against cremation. Why doesn't that implicate the
Because
First Amendment?
it doesn't implicate, because we're not, there's no affirmative action that the Coptic Church needs to take. They
Is that
simply
the
need not
only thing,
interfere.
is that the only First Amendment right that churches have? That they not be forced to do something, that they need to tolerate on their land something that is offensive to their religious beliefs? That's okay, but
It
as
is
long
in
as
this,
they're not required to do something?
yes, in this case, because they purchased with full knowledge of the existence of that
And that
burial
it would be
ground.
removed?
They were wrong about that, is our
Uh-huh.
position. And so the
Well, that's
common
my
law is
question,
trying
is
to
that-
balance.
Yeah.
But then you're imposing the obligation on the other church. Because, I mean, we're stuck between two churches, right? And also burial practices, which is sort of an important religious activity. So, and and you subtly seem to avoid the way the regulation reads, they have a perpetual obligation, right? But now you're saying not really, because I take it you're worried about their First Amendment problem, which is they can close their church, right?
They have the right to close their church.
So then if they have the right to close their church, that perpetual maintenance can't mean that they have an obligation to perpetually maintain it, right?
Well, I think they might, and that
Well,
that
but then-
issue was
then we're-
actually remanded.
But then we're telling the church that they not only can't close, but they have to keep operating a burial ground. Doesn't that get First Amendment-y?
No, Your Honor. So there's no challenge to their right to close. We've never argued that they must stay open. That's not at issue before the court.
Now,
In
that
terms of
isn't-
maintenance, I'll just say that.
Isn't that why church burial grounds are different than private burial grounds? Because, I mean, we understand there's tremendous sensitivity to disinterring.
I think here, in some of the case law, like the Trinity case, where perhaps there are tombs beneath the church building, it's a different situation. Here we have a memorial garden set off apart in the corner of the lot. This particular area of land was purchased by the church specifically to create this memorial garden. They added another acre or so of land. There's a map in the record, and you can see the boundary lines and then the entirety of the lot.
So why does the geography, whether it's in the actual structure of the church or on the church's land, change the First Amendment implications?
Well, two things. One, it changes the analysis of whether or not there's justification for disinterment, which I started to talk about at the beginning, which was, is the property abandoned or neglected, or is there some other condition that makes it unsuitable to continue as a burial ground? The First Amendment issue.
But isn't the answer to that the church sold the property and it's no longer a church burial ground because the church has closed this?
And that's, Your Honor, that's what the trial court found, that it was no longer in use. And the appeals court agreed with us that that's not the test. It's not whether or not there are additional internments or whether it's used by an operating church. The test is whether or not the area has been abandoned. Is it neglected?
Well,
In the common law-
that may be a misinterpretation of the law.
So
That may diminish the First Amendment rights of both churches.
The First Amendment would be implicated if this court was weighing in on an internal church decision. And that's not the case here. Just because the
But
property
we're
owner...
weighing in, you're asking us to weigh in on two church decisions. One, closing one, and two, requiring another to maintain a burial ground that includes cremation, which is against their religious principles. I just
Your
don't.
Honor, respectfully, we're not asking you to weigh in on the closure of the church. There's no dispute on that issue. We agree that the church has a right to close. It doesn't have to operate any longer.
And they don't
Here-
have to maintain the garden then, right?
Well, we think that, and this was what was remanded back to the Superior Court, we think the common law allows the families the right of basic maintenance of the area, removal of brush and debris and repairs. We think that the contract
Yeah, but
here,
you're
they
asking
also-
us, you're asking us to enforce that obligation on the church. You're asking this court to say the church has to maintain that ground, right?
not not the case that's before this court today.
That's the
You
next
don't have to
case.
decide
That's the
that
next
issue.
case.
That's the next case.
And
That
where
was-
would that next case lead?
So I think the trial court would have to look at the churchyard regulations and the certificate of interment and decide whether or not the Episcopal diocese has an obligation to pay for the ongoing maintenance. And they could do that through contracting with a third party. And remember, when,
They
if you
not
see the
do it?
church, I'm sorry,
Could they just not do that?
we would submit they may be in breach and subject to
But
those
how
costs,
is,
but-
how is that the Episcopal Church exercising its right to sell? Because, you know, you keep parsing this out, this part about the maintenance of the garden. And if you're saying you're not challenging their right to sell, they're selling everything. Their intention was to sell everything, including any responsibility for the garden. And by your definition, if you're reserved the right that's remanded, and you could go now back and say, you just said that they may potentially be in breach, how are we not squarely in the Hobson's choice that Justice Kafker just keeps going back to, but you seem to disagree with?
This was a parish of a larger diocese, and although the parish closed, the diocese itself continues to exist. And they've generated $1.8 million from this sale, which we think would enable them to continue to maintain this site. So, but again, that's an issue for another day. That's not what this court's being asked to decide at the moment. And I also don't think that implicates the First Amendment, because you would be enforcing their contractual obligations. This court, civil courts can apply neutral principles to enforce contract obligations, even when a church is a party
Okay,
to
but the
that contract.
contract, again, included the fact that the remains would be disinterred, so,
The purchase and sale included that,
Right.
but the underlying certificate of interment and the churchyard regulations did not.
okay. Thank you.
Thank you.
Attorney Miller.
Good morning, Your Honors, and may it please the Court. Jennifer Grace Miller here today on behalf of the Episcopal parties. Your Honors, no one wants or expects to close a beloved neighborhood church. Certainly not the diocese, certainly not the parish, certainly not the parishioners. But when that difficult decision is made, then burial certificates like the ones issued by Holy Spirit to its members entitle the holders of those certificates to respectful removal of the remains.
Oh,
And-
that's not what it talks about perpetual maintenance, right? It doesn't talk about, there's nothing in the regs that talk about respectful disinterment, right?
Right, but the cases do, Your Honor. And the burial certificates themselves were written with the background of those cases, which use roughly the same language to discuss the burial right.
How about the regulations? Could you speak to Counsel's point about the vast majority of the folks who had cremated remains agreed to this, right? So you have a small number that said, no, this isn't okay. And now, unable to get 100% yield, 6 months after the date of consummation, these rules and regs are changed. What is reasonable about, or if you listen to your brother saying, you can't do this after the fact. You couldn't get it beforehand, so now ex post facto kind of, you go back and you want to do it after the fact.
So I'll start my response, Your Honor, with a query about whether or not it is within this court or any court's jurisdiction to unpack the reasonableness of a church's decision about its internal governance.
I don't say that we can. I posed the question about whether or not that's a trial issue.
Right. So, Your Honor, I don't think it's a trial issue, and let me back up. I think it's not because there is an issue of law here that is on all fours with all of the agreed facts, so I don't think we need to go back, because it is a question of law. And what I'd like to go back to and do is to talk about the cases themselves against which these burial certificates were drafted. So the parties have been skirmishing to some extent about two allegedly different lines of cases that have developed. But in point of fact, you can rationalize them. In the Hines and Sanford and Treffry cases, you had a circumstance where, because the property was on family burial ground or former family land, there was no affirmative act by an appropriate authority to close that burial ground. So without any statutory guidance or support, the court was left to decide, does it continue to be a burial ground? Because the baseline rule is essentially the remains should not be disturbed so long as it remains a burial ground. Now here's the difference, of course. In the Trinity cases, and in Kincaid, and in Partridge, and in Richards, and all the other cases that are cited in our brief, you have a different set of circumstances. You have an affirmative decision by an appropriate authority, whether it's a church exercising its ecclesiastical authority, or a legislature exercising its police powers, or a court exercising its equitable powers. Some appropriate authority had ordered the burial ground closed. And that instance, in what the cases say, which is supported by both the Massachusetts statute and the words of the burial certificates, what the cases say is that there was a license to be buried that is revocable when it is closed by an appropriate authority. And therefore, once the decision is made to close, and again, my brother does not contest that that was a legitimate decision to close. Once the decision is to close, then it is a license that has been revoked, and what you are entitled to is exactly what the Episcopal Church provided.
I get and your rule sounds attractive in the sense of appropriate authority, but it seems to me it's a First Amendment rule, because if this were a corporation, some burial corporation, right, and they had entered into something that said, we're going to perpetually maintain your burial ground, your plot, we wouldn't be here, right? It's that that authority is limited. That authority can be limited by its own terms. Here, we're just reluctant to limit it because it's going to run right into the First Amendment, right?
Well, I think there are two responses to that, Your Honor.
Not just that it's an authority, it's an ecclesiastical authority with religious rights, right?
It is, and I'm not diminishing that at all. But I'm also making the point, Your Honor, that I'm going to use the example of the Quabbin River Reservoir.
Mm-hmm.
So we cited that in our brief. To build the Quabbin River Reservoir, 7,000 graves had to be removed under the legislature's power of eminent domain, assuming that there were interments in public cemeteries. Nowhere in the burial certificate, even if it did promise perpetual care, which is a pretty usual term, obviously the...
I don't know, if this were, let's use your example, but it's, government takes property, it has to compensate people. We might be compensating for emotional distress and all kinds of other things if this were a governmental taking, right?
Right, but the cases actually address what they're entitled to with respect to compensation in the burial certificate instance, Your Honor. And I just want to back up one second.
Your regulations don't do that at all. They, if anything, sort of leave the impression that this is going to be perpetual.
Well, it's perpetual in the sense, Your Honor, that it wasn't for a day, a year, or for a specific term. The perpetual care would continue for as long as it remained a burial ground. And once the license is revoked, because it is no longer a burial ground,
Words ever appear in this? Perpetual as long as it will remain a burial ground? I don't remember reading that.
no, of course not, Your Honor. But in the cases that we cite, they use very similar language where the burial site or the certificate was subject to the regulation of the church or some other authority. And that's the difference. When you use that language, you're not writing on a blank slate. You are writing in full knowledge of the fact that other courts for decades, for hundreds of years, have interpreted that language to give the holder of the burial certificate after a burial ground closure the right to, again, respectful removal and reinterment.
What about just contract interpretation and the fact that the regulation was after the sale?
Well, again, Your Honor, I think the critical point is that there was a decision to terminate of the burial ground, whenever that was made. So I'm not sure the timing makes a difference with respect to what the obligations of the Episcopal Church were. But
I'm getting at the reasonableness of the contract, the meeting of the minds, the question Justice George has asked about whether or not we've got a factual dispute on reasonableness.
right. So, Your Honor, there's no question that the burial certificates themselves left control of the property entirely in the hands of church officials. As we've all noted, there is this enormously broad caveat which says that it is subject to the regulations, and not just subject to the regulations, but subject to them as they might change. And the churchyard was subject to the regulations. The regulations were subject to the authority of church officials, and they could change at any point in time. So it is unreasonable to look at a contract that is otherwise extremely simple. If you look at a contract that, as its primary term, contains this enormous caveat, to read that as providing a perpetual right of interment that survives the sale of property and survives this decision to close, Your Honor, we would argue that that is entirely unreasonable.
Do you even accept this reasonableness? Because, I mean, we don't normally question reasonable belief in the religious context.
Right.
Are we running into trouble if we subject? Do these regulations have to be reasonable, or these regulations, they're the church regulations, and we stay out of it?
Correct. That would certainly be the church's position. If we were to go back to trial, one would expect that the issues would be what were the expectations of the party, and that would be all about what church doctrine is and church authority is, and that is just simply an inappropriate place.
Why wouldn't it just be basic contract?
Because, of course, this is a contract between a church and its congregants.
Sure, but I mean, it's a contract for their for this license that you keep talking about, right?
And as long as we interpret it with respect to the cases that have gone before interpreting the same language, then that is a neutral principle, and that is fine. But the moment we get into whether or not the church decision to close was reasonable, the church's what the church chose to close, whether it's the church or the churchyard, whether that was reasonable, that's an inappropriate thing. This is all about internal church governance, which this court has been chary of wading into in this sort of context of the church closure, which, of course, unfortunately, we are seeing more and more of.
Counsel, could you help me understand one thing, though? The regulations were changed after the sale, and included in the sale was the area where the remains were. Can you help me understand? It may not be. I just don't see the standing issue. Can you help me with that? How is it after the fact that they get to?
Well, I think the hope was likely that all of the parishioners would agree.
Mm-hmm.
Once there was a clear objections, and once the closing was upon them, or the extension period for to resolve this issue was up, I would, although this is not in the record, then presumably what the church was doing was giving some confidence to the purchasing church that this was well and truly closed, that the church had made the decision that this was closed.
Thank you.
Thank you, Your Honor.
Thank you. Okay, Attorney Botros.
Good morning. If it pleases the court, my name is Attorney Audrey Botros, and I represent St. Philopateer and St. Mina, Coptic Orthodox Church. I'm here today not only as an attorney, but also as a member of the Coptic Orthodox Church. And I believe my sister addressed a lot of the issues that we, of course, are on the same page as them. The main issue that concerns us with the decision from the appellate court was the addressing of the Coptic Orthodox Church's implications on a decision to maintain this garden. The appeals court says, we fail to see how a judicial order preventing the Coptic Church removing the remains would constitute government interference with the church's free exercise in religion rights. And they don't see how there would be any affirmative involvement in the Coptic Orthodox Church with maintaining this garden. This ongoing issue has gone on for 7 years now and has greatly impacted the Coptic Orthodox Church. This church was purchased, as the record shows, to expand the existing church, to expand a Sunday school building from the church. The church has been unable to do that for 7 years. They have completely outgrown the small parish on this property. They can't build anything, they can't design, they can't move forward. There's a case that was cited, Society of Jesus versus Boston Landmark, with, I find, very similar issues. The appeals court distinguished this case, but I really see identical issues in both cases. That case, they wanted to designate an altar as a landmark, and the court found that preventing the Jesuits from altering their church for the purpose of their religious was a constitutional violation. In our case, the Coptic Orthodox Church, I don't know if any of you have ever been in an Orthodox church, has very particular design. Every church we have purchased, and thank God we have a growing congregation, was changed architecturally to suit the Coptic Orthodox style of service, including an iconostasis that runs across the front of the church. So we purchased several Catholic churches. We purchased Episcopal churches. Every church has been transformed because that design implicates the way our service is done, our liturgy is done, and one of our most important liturgies on the Feast of Resurrection or Easter, that has a functional purpose. If you walk into that church in Wayland, you will not see that iconostasis. You won't see important parts of our religious.
Can you? I mean, you're engaging in a purchase. That's the thing that you're buying with a certain level of risk associated with it. I mean, like, say you bought you're buying from another church.
Yes.
What if that other church insisted that you maintain something because it was important to their religion? If they insist that you do that, then we have competing religious rights, and you can avoid it by not purchasing the property, right?
Yes.
So would they be allowed to do that? Say the church wanted to keep this memorial ground because it was important to their religion.
Yeah, I'll tell Your Honor, we've purchased several churches and I've been involved. Our office does a lot of pro bono work.
Yeah, I'm not.
We haven't come across that situation, is what I'm saying to you. If it's something that greatly disagreed, like pretend they asked their church to have a marijuana dispensary.
Well, no,
if it greatly
but my question's a little more
disagreed with
particular.
our beliefs.
It's a little more particular. It's your as a purchaser of property. I just don't know how far your religious rights go because you are buying at your own risk. It's not like we're telling you how to operate. We're telling you that your purchase may be subject to certain conditions.
Yes, it would depend on the conditions, as I mentioned. I mean, our church, dates back to 42 AD, one of the very first Christian churches. We're very particular in our style and what we believe, and, we've kept that through years of persecution in Egypt. But this garden has greatly impacted us, and it's continued to. That the land has a lot of areas that are not buildable. For us to expand and do what we want to serve our church, our community, we haven't been able to. And we do respect, the wishes of the people, but we also have a congregation to serve as well.